The year is about 10 years ago. Right in this very spot, although actually up a little bit, walked a little girl. Happens to be my daughter. She's in college now. And she was an evening class of property students who'd come in from work all over the state of Connecticut, big class. And she stood in front of the class and she said, "No interest is good unless it must vest or fail to vest within some life or lives in being at the time of the creation of the interest, plus 21 years, plus periods of gestation, period." And she walked out of the room. All those poor people who had dragged themselves in from work for a property class heard this, then I guess 8-year-old girl recite the rule against perpetuities word for word perfectly. She didn't understand a damn word she said. She memorized it because I used a good learning technique called the carrot. I said, if you will learn this and go in and say it to a class, I will give you whatever CD you choose. So she got to choose a CD by whoever she wanted to listen to. So we practiced it, going back and forth to school. Didn't take very long. She wasn't trying to understand it, just learned to say it. She got it perfectly. She still remembers the damn thing almost perfectly all these years later. I mention this because the registration form that I gave you, I asked, list any concerns you have about the bar, and a fairly common concern on the list was, how am I going to remember so much stuff all at once? And my answer is, number one, you're not. Don't worry about it, nobody does. You're not going to remember it all. 10,000 separate little legal rules, all up here like no interest is good? No. You're not going to remember them all. You don't need to remember them all. Nobody else in taking the test remembers them all. But you do need to have a fair number of simple, straightforward rules about very basic things ready to call forward and use without having to give it a whole lot of thought. Oh my God, what do I mean common law murder? What is that? Well, no, you can't be sitting there writing an essay in which you need to know what common law murder is and saying, gee, now let me think about this for a while. You've got to know common law murder is killing of another human being with malice aforethought, and malice can be proved in 4 ways, and here they are. You need to know those things that are tested with great regularity and those things that are tested less regularly. But you do need to have a fair amount of stuff actually understood and remembered. But that doesn't mean you need 10,000 flashcards and to memorize them as if they were numbers in a phone book, a bunch of nonsense, the way Rachel learned the rule against perpetuities. Rather, I'm trying to give you in this class a method of learning and remembering that which you need. Pull up a place anywhere. That which you need that will work to get you to the point where as I said, when Barbary starts, for those of you doing the July bar end of next May, early next June, most of the basic stuff in the big 6 subjects will already be there for you. And when you hear the Barbary lectures, which will be far more detailed than the lectures I'm going to give, you'll say, yes, 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 yes. Oh yeah, I know that. Oop, that's something new. And it will not be overwhelming to you. And when you walk out of the bar next July or next February, for those doing it in February, you won't walk out of the bar and say, as I said, I heard a dean of a law school actually say to his students, I walked out of the bar and I flushed down the toilet everything I had crammed for those previous 6 or 8 weeks. I want you to learn it in a way that you say, hey, I really understand it, I can use it, and 10 years from now, I might be calling Rich and saying, guess what? First time ever, I never thought I was going to have a defamation case walk into my office, but in walked somebody and they told me this story and I said, oh, that's defamation, and I knew what they were talking about and I knew what to think about. That's what I want. I want you to have those basic legal tools accessible to you in a way that stays with you. So the method is this. you read one of Barbry's wonderful outlines. They are very dry. They're a little bit more interesting than reading a phone book, but they don't have an exciting storyline, right? But if you read them intelligently, and I mean literally read, I mean you don't, oh my God, that paragraph's not hard and spend an hour on it. You just read it through. Then you come to this class and you attempt to apply it, which means you have to call forward what you remember and understood, and you get feedback on how well you did or didn't understand it in applying it to MBE questions, and really importantly, in trying to actually call the stuff forth and put it on a blank piece of paper for essays. And then you get back and you reread. In light of having tried to apply it, and then you go to apply it again. And we will do this 7 or 8 separate times with each of the big 6 MBE subjects. Result, on the 3rd reading or the 4th reading, stuff starts to come together really well, and you say, yeah, okay, I've got that. I can tell that story. Torts is a story. Contracts is a story. I've got the story. I've got the parts. They're making sense. I come to the stuff in torts, the hardest part is doubtless the discussion of proximate cause in negligence. I'm coming to that and I'm saying, oh yeah, I see this. It's beginning to really make sense now. You're making connections between things. You know, on the first reading, how can you be making connections between things that are on page 6 and things that are on page 99? Well, you can't. I mean, Barbary has little cross-references. Don't worry about them. But by the time you're on your 2nd, 3rd, 4th reading, you say, oh, this connects to this. You're making those links up here in your mind. And then when we get to another subject, contracts, criminal law, etc., you're making the links across from torts to crime, torts to contracts, and so forth. And in the end, I'm going to warrant, with no remedy if it fails, that you will really see things that you never could or would have seen before. I do all the time. I say, oh, look at that. That's interesting connectedness among things that you get by doing it this way. So, sometime last year, there was an article, front page New York Times. I don't know why, front page New York Times, whenever somebody comes up with a great study of how people learn, they put it front page New York Times, generally upper left-hand corner. This one said, scientists at Purdue study how people get things into their long-term memory. Not short-term, long-term memory. And they tried, had people studying the same materials in several different ways. They were using scientific materials. But one was very active reading. Read it very carefully, tear it apart, make your own little charts and notes and everything, which a lot of people think is great. Maybe is. And another was read it through, try to apply it, see what you remember. Read it through again, try to apply it again, see what you remember. The read it, apply far exceeded their expectations and was the best for long-term memory. They didn't know why. I could have told them if they'd asked. I actually had an email exchange with them asking them if they'd like to study how it works for legal learning, because I said I've been doing it this way for years. It works. So I'm asking you. I would get down on my hands and knees and beg, but I'm old and I don't bend that well anymore. But try. And don't use, I couldn't do it as an excuse for not attending, but try your best to actually read the outlines before the classes. So you have a 100-page torts outline. If you read half of it before each torts class, that's good. Okay? But today I'm going to talk about how I want you to read it so that I think it will be easier for you to remember and easier for you to understand what you're reading. I'm a big picture guy. Remember starting law school, day 1, day 2? Read these 6 pages, a case from 1400. Read these 6 pages, a case from 1703. and you're reading stuff, you have no idea what it's about, what its context is, nothing. There's no context to it. I found that as a law student an incredibly frustrating way to try to learn torts. And somewhere along the way I said, well, I won't say exactly what I said. I was probably a little off color. This is not a good way for me. Nobody in my law school gave an overview at the beginning and said, okay, now we'll get to the detail, but let's have a big picture first. I always give the big picture at the beginning, any class. Big picture. So I just said, this isn't working for me, and I sat down and I read a book on torts. I said, oh, that's what torts is about. Now I can look at the individual parts and make some sense out of them, but if I didn't have a big picture, this, look at this, look at this, look at this, was not a good way for me, at least. Where's Death Valley? Anybody here ever been in Death Valley? Yay, okay. A couple of other crazy people, I've been there. How do you locate Death Valley? Well, locate anything in terms of where it is in some bigger context. The United States, the Atlantic Ocean, the Pacific Ocean, the Appalachian Mountains, the Mississippi River, the Rocky Mountains, the Sierra Nevada Mountains, the Pacific Ocean. That's the United States. Canada up here, Mexico, Gulf of Mexico down here. That's the overall picture, right? Where in this picture is Death Valley? Well, you have to go to the other side of the Rocky Mountains, and there's this huge amount of deserty country. And if you go from Arizona north through Nevada on the very western side of the state, what's there to your left? The Sierras, which divide California from Nevada and Arizona. Sierra Nevada mountains, very, very high. And Death Valley is nestled right there, right before you get into the high Sierras. So you head north in Nevada, past Las Vegas, stop and gamble if you want, keep going, and 150 miles north, swing west, and you'll know you're in Death Valley because it's hot, right? It's got a location in the overall map of the country, and I can find it and locate it. Well, I want you to think about torts and all the other subjects I'm going to ask you to study in this kind of big picture. What's the big picture? And then what are the smaller parts and how do they fit together? So I'm going to tell you, when you look at an outline, 100 pages of, as I said, very fascinating reading in torts, and you start to read it, I can tell you that the Barbary Outline does a very good job, better than the other companies out there, of covering what's covered on the bar in torts. But if you really want good coverage, you'd read the restatement of torts. Restatement second, the parts that are still in play, and restatement third, so it'll be about this much, right? You read 3,000 pages. The people at Barbary, and these outlines go back many years and just get moderately adjusted from year to year, have taken that 3,000 pages of rules and exceptions and comments and examples from the restatement of torts and got it down to 100 pages for you. So it's not like 100 pages is long, it's 100 pages is short. It's a condensation of the 3,000. But it gives you enough information to actually be able to answer 99% of the questions that ever appear on the MBE. But I don't want you to memorize it, I want you to read it and understand it. So I'm going to say torts, logically in my mind, divides into 3 parts, and it's not going to quite fit. I gave you over there a kind of a set of, an outline of basically what I'm going to be talking about today, so you can kind of follow along. You all have that, right? My structure for torts differs a little bit from that which you will see in Barbary. If we look at the, well, let me step back 1 second first. A couple of general comments about torts before I look at that. Number 1, you want to be aware as we go along of relationships between torts and some of the other areas of law that have similar concepts. The biggest overlap is between torts and crimes. because they grew up together. Same behavior by a person can lead to a suit for damages or a prosecution to send somebody to jail. You killed somebody, suit for damages, prosecution for homicide, that kind of thing. So the assault and battery in torts, assault and battery in crimes. Self-defense in torts, self-defense in crimes. A lot of overlap. But when you have the same terminology in two different areas, you want to be aware that very often it means somewhat different things because of the context. So that's one big important thing to be aware of as we're studying torts. But maybe the single most important thing, the most important thing in all of your approach to torts is everything that needs to get discussed in an essay, everything that you're likely to be asked in an MBE question centers around name a tort and state its prima facie case and apply. Don't try to just intuit to the answer and start discussing what intuitively seems to you important without thinking, what tort is this? And what is the prima facie case? What must the plaintiff prove? If that seems too obvious to you, it ought to be obvious, except people often don't do that, and they get screwed up. They get to intuiting to answers. So when you look at a set of facts, of behaviors that occurred in the real world, Jones got into a car accident, Smith had a hunting accident, Jones said that Smith was a prostitute, whatever behavior out there in the real world, you say, okay, what tort categories can I apply to this? Defamation, battery, whatever. And if it is a plausible one, you need to know, eventually, the elements of what we call the prima facie case, which is nothing more than the things that the plaintiff must prove, and if the plaintiff can't prove them, plaintiff loses. So you can have ready, long before you walk into the bar, simple sentences to go with each of the basic torts. In battery, plaintiff must prove a voluntary act intended to cause and causing a harmful or offensive contact with a person of another. In defamation, plaintiff must prove a defamatory statement of or concerning a published causing damages, and if we fit one of the constitutional categories, plaintiff gets some additional burdens that we'll talk about later. Plaintiff's case and what defenses go with what tort. That's what you really need to know and recognize. And as I said, you don't want to be sitting on the exam saying, what are those things? For those things you don't need them today, but before you walk in there, you want to just have them ready to apply. Okay? So, that's what you're going to organize the details around. But before we get to the details, let's take the big picture. All of the law of torts divides into three parts. Everything. First, most of the law of torts divides into torts by fault level that the plaintiff must prove. Second, there are some other torts I have labeled as miscellaneous torts where you don't really organize it around fault level. Several different fault levels might be involved, miscellaneous torts. And finally, least important in terms of the bar at least, but not unimportant, general considerations that apply broadly through the law of torts, not limited to a particular tort. So we have torts by fault level, then we have miscellaneous torts, general considerations, that's it. Everything's going to be in there. Now you can see this in Barbry's table of contents, but I move things around a little bit because I don't like where they put some things, but basically, torts by fault level. Intentional torts, you've heard of them, right? Negligence, the big catch-all category, strict liability. Again, so in our intentional torts divide into three parts. Our torts by fault level divide into three parts. Intentional torts, negligence, strict liability. That's it. Our miscellaneous torts, we have a couple of big categories. Product liability is the biggest thing that I'd label miscellaneous because you can use all sorts of different fault levels with products. Secondly, economic and dignitary torts, which Barbry for some reason, puts up it early on, pages 21 to 44. They put it right with the intentional torts. I don't think it belongs there. Because different fault levels involved. So I'd say that's a miscellaneous group of torts. And economic and dignitary torts are what? Defamation, invasion of privacy, interference with business, misrepresentation, all sorts of miscellaneous torts. And the other big one, there's not a lot of pages in Barbary, but it comes up all the time, nuisance, where it can be intentional, negligent, strict, nuisance. What's the key to nuisance? It's an interference with person's use of property. So we have these groups of miscellaneous torts that don't fit neatly into the fault levels. And then we get to the general considerations, which is the last 10 pages of Barbary's outline, page 90 to 100, right? And you'll notice I gave you a recommended amount of time for reading the whole thing based on my experience. Different people read at different speeds, but I gave you a thing. I said, study the table of contents for about an hour, spend about an hour and a half on the intentional torts, about 2 hours on negligence, a half hour on strict liability, go to the miscellaneous torts, 1 hour on products, an hour and a half on economic and dignitary, about half an hour at the most on nuisance law, and then about an hour on general considerations. That's how I divide it up. So you're reading, not just reading words, but you say, okay, now I'm on the dignitary torts, now I'm on product. You're aware of where you are in this big roadmap. So as I said, we have, over in the fault level torts, we have intentional torts, we have negligence, and we have strict liability. Intentional torts divides again into 3 parts. I love 3 parts. 3 or 4 parts are nice, right? 3 parts for the discussion of the intentional torts. Some of the intentional torts are intentional torts to the person. Some of the intentional torts are intentional torts to property. And then we have to consider as a separate matter, what are the defenses that are available to the intentional torts? That's it. Now that's going to be 5, 6 questions, maybe 7 questions on the MBE. It's tested all the time, various parts of this. So what are these intentional torts? Sounds like intent must be critical because I'm calling them intentional torts, right? And that's what they're called, the intentional torts. But if you don't know what intent is, what can you do with intentional torts? So actually Barbary does, although it could be a little clearer, but at the beginning, before you get into the individual named torts, there's a brief discussion of what are the characteristics of the intentional torts generally before we look at the specific ones. And the general characteristics, prima facie case in general for the intentional torts is going to be, first, we need a voluntary act. Second, that voluntary act needs to be intended to do something, intent, and then it needs to actually cause something. So intending to do something is not enough. I have to do an act intended to cause, and I actually have to cause whatever is the basis of that particular tort. That's going to vary depending on the tort. Voluntary act, intent, causation of whatever makes it that tort. Interestingly, for most of the intentional torts, you do not need to prove actual monetary damages. At a point to your score on the MBE, it's almost always tested. Which torts require actual damages, which torts don't require actual damages, and what kinds of damages can you collect in which torts. There are things that same set of behaviors, if you sue in negligence, you lose because you don't have the right kind of damages, but if you reconceptualize it as nuisance, now you can win because you get damages for interference with use and enjoyment of property. You don't get that in negligence, you get that in nuisance. But for most of the intentional torts, actual damages are not a requirement of the prima facie case, although, of course, if we can prove them, we want to prove them because that gets more compensation for our client. Now, having read 3,000 answers to essays, same over and over again, I can say that there seems to be a total confusion about the relationship between a voluntary act and intent in a large number of law students. Voluntary act, by definition, restatement of torts, is any movement of a muscle controlled by one's consciousness. I move my finger. I squeeze a trigger. I pull back the arrow in my bow and arrow. It does not require any more than that for a voluntary act. I made a conscious decision to move a muscle. I started to fall, and I reached out consciously to touch that chair to break my fall. Whatever. Conscious movement of a muscle. That's not the same thing as intent. Intent, were my 8-year-old daughter standing here, I could say, honey, what's intent mean? And I don't know, intent's a regular word in the English language, right? I didn't intend it. I didn't mean it. But in the law of torts and in the law of crimes, what we mean by intent has a specialized meaning, and it's very useful if you actually know what it is. So restatement second of torts, and somewhat adjusted. I've been studying recently the restatement third, very interesting modifications of restatement second. But they agree that there are two ways to prove intent. Barbara labels them specific and general. I don't think that's particularly helpful, but they are, number one, one intends if one has something as one's purpose or goal. My goal is to hit Jones. My purpose is I want to hit Jones. That's why I'm aiming my arrow at Jones. So it's not just the voluntary act of pulling back on the bow. It is also, now the intent is I'm aiming at Jones, knowing that he's there and saying, boy, I really want to hit Jones. My goal, my purpose is to hit Jones. That's one kind of intent. Second kind of intent, I'm guessing some of you may remember, there aren't that many memorable cases in first year that should stick with you for all of your lives, but Garrett against Daly. How many remember Garrett against Daly? Ah, okay. Christine, would you stand over here? Now, pretend Christine is right in front of the chair. She's an old lady, right in front of the chair. She's an old lady. She's about to sit down. I'm a bratty kid. I see she's about to sit down. I pull out the chair. Don't. She falls to the floor. That's Garrett against Daly. Bratty little kid pulls out chair as he sees an old lady going to sit down. Court says it doesn't matter whether his goal is to cause her to hit the ground. All that we need to show is that he knew. His experience in life was enough that he actually knew with substantial certainty that if he pulled out the chair and she was in the process of sitting, she was going to fall to the ground. So that's the restatement definition of intent. Either one has whatever makes it that tort as one's goal or purpose, or one knows with substantial certainty. Either one of those will do for intent. Or a third thing that is not as explicit in the restatement, it's mentioned in the comments but not in the main text, but is still widely accepted. We have a thing called transferred intent. Remember that concept? If I intend to cause a battery on person 1, but I actually cause the contact with person 2, we transfer my intent to cause the battery on person 1 to person 2. If I am aiming my arrow in front of to cause an apprehension in Christine, I want to cause an assault, I succeed in whatever, but I hit the guy behind her who I didn't even know was there. We transfer the intent from an assault to Christina to a battery on the person I actually hit. The doctrine of transferred intent works among the traditional intentional torts. Assault, battery, false imprisonment, trespass to land, trespass to chattel, and nothing else. We can transfer theoretically among those an intent to cause one of those kinds of invasions that actually causes another, and even to a different person, the intent will be proven. Voluntary act, movement of a muscle. Intent, desiring the consequence or knowing with substantial certainty you're going to cause the consequence. And then causation, did the act actually cause the invasion? And then we get to the torts. What are the torts? Assault, battery, false imprisonment. Let's start with those. For assault, you need all those things, voluntary act, intent to cause, and causing. But what makes it an assault? apprehension, whatever that means, of an imminent, whatever that means, harmful or offensive contact with a person of another. Battery, voluntary act intended to cause and causing. I'm not saying anything today I'm not going to say a billion other times, so you don't necessarily have to write all this down, but it's up to you. Voluntary act intended to cause, causing what? Harmful or offensive contact. Is a very big word in the English language, or, that they trip people up on all the time on the MBE. I don't have to intend to cause harmful contact, I have to intend to cause harmful or offensive contact. Either one will do for a battery. Okay? Whatever those things mean, and that's, if I had 10 or 15 hours to stand here, I could give you everything that's covered in the Barbary Outline in a 10 or 15 hour lecture. I don't know if I could do that much without notes. I probably could do most of it, but I'm not going to do that. I'm going to depend on you to actually read the stuff, the more detail that you see in the Barbary Outline. False imprisonment. Voluntary act intended to cause and causing. Confinement. Whatever we mean by confinement in a bounded area. And does the person have to be conscious that he is confined? Or if you confine someone who doesn't know about it, will that be sufficient? Yes, if there's actual injury and so forth. That's false imprisonment. Confinement. But false imprisonment turns out, if you get into the details in Barbary's outline, there's some, to be more complicated than assault and battery, because there's so many times when an imprisonment or confinement of someone might be justified. For example, a police officer arrests somebody. A private person arrests somebody. Yes, private people really can arrest people. And if they are justified within the rules of law, then it's not a false imprisonment. So you need to be aware that there are a lot of limitations on false imprisonment in terms of whether there is a privilege to arrest the person. And that's the three traditional intentional torts to the person. But there's a fourth, much more recent and not universally recognized intentional tort to the person that is called intentional infliction of emotional distress, often abbreviated IIED. Don't abbreviate it, IIED, but know what it is, okay? Now I'll tell you right now. Actually, I guess it's my first chance to actually say this. Yeah. When things sound a lot alike and have a lot of overlap in them conceptually, and you are a devious person trying to write a multiple choice question, you're going to try to mix people up with those things a lot. So you're going to give a fact pattern that is a negligent infliction fact pattern, and put down an intentional infliction answer that will look really good but be wrong because we're in negligent, not intentional infliction, and vice versa. So here's a little cross-reference from IIED, which is early in the outline, to negligent infliction of emotional distress, which is way back far into the negligence discussion. What is the connection between them? But let's start with IIED, because that's where we are. Relatively more modern conception than the others, and it requires the act is not just a voluntary act, but the act has to be extreme and outrageous. Extreme and outrageous. Okay? And the intent has to be an intent to cause severe emotional distress. And we have to cause severe emotional distress. And we need actual damages. That's when we need actual proof of damages. So what is going to be sufficient for extreme and outrageous? Look at the Barbary outline, we'll see examples. What's severe emotional distress as opposed to just minimal emotional distress? Okay. But the most important little distinction, other than the extreme and outrageous, is this is listed with the intentional torts, but actually the definition says it's intentional or reckless infliction of emotional distress. So the nice little categories, intent, negligence, strict, there are sometimes some things kind of on the borderline. We have this concept of recklessness, which appears from time to time as kind of in between intent and negligence. Reckless basically means more or less the same thing in criminal law that it does in tort law. We use recklessness, reckless murder, and we use recklessness with IIED, and we use recklessness when we get to defamation. It's used all over the place. What do we mean by reckless? Without wreck. It means that the plaintiff has to prove that the defendant was consciously aware that his acts were creating a very high risk of some invasion, and he didn't care. Went ahead and did it. Good example of this is a person who's studying for the bar examination, but didn't have this class, so they're very tense, and it's 2 weeks before the bar, and they're in their room studying for the bar examination, and next door people are having a loud, noisy party. So he calls them and says, "Hey guys, I got a bar examination coming up. Could you turn down the music a little bit?" They say, "Oh, sure, we'll turn down the music. Sure, we will. Ha, 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 ha." They turn it up. So he calls them again. "Hey guys, really, seriously, this is really important. Could you please turn it down?" They turn it up a little more. He goes to his closet. He pulls out his Uzi. He goes over to his window. He sees a house from which the noise is coming, and he sprays a half a dozen bullets into it. He's not aiming at any person in particular. He doesn't desire to hit anybody in particular. He's not substantially certain of actually killing anybody. But he certainly has to be consciously aware that when he shoots his Uzi into a place where there's a noisy party going on, that there are people on the other side of the wall, and he's taking a great risk of killing someone, and he does it anyway. That's recklessness. Conscious awareness, high risk, you do it anyway. Okay? That's going to be true in all sorts of areas of the law. That's what we mean by recklessness. So that's enough for IIED is really intentional or reckless infliction of emotional distress. Those are your elements, right? Done. Property. Intentional torts to the property. 3 only. Trespass to land, trespass to chattel, conversion. Trespass to land, trespass to chattel, conversion, right? Trespass to land, see your course in property, right? It's not just a tort concept, it's a concept that has a lot of significance in property. We need a voluntary act that's intended to cause and causes an invasion, a physical invasion of somebody else's real property. But very interestingly, I think the best way to understand the intent for trespass to land is the intent and the voluntary act kind of merge for this. If I voluntarily put my foot where it is, and that place where it is happens to be someone else's property, it doesn't matter whether I know that it's somebody else's property. It doesn't matter whether I even believe that it's my property. It doesn't matter whether I even reasonably believe it's my property. What matters is I voluntarily put my foot someplace, and that is somebody else's property. I'm a trespasser. See, the difference is the voluntary act and the intent now have kind of merged. Put another way, mistake is irrelevant. And that's tested all the time. It doesn't matter that the defendant reasonably believed. What matters is the defendant put his foot or shot his arrow or caused some other invasion of somebody else's real property. Trespass to chattel, by the way, compare, little cross-referencing at this point, compare trespass to land to nuisance, which is way back with the miscellaneous torts. But they're tested together often. And if you have an essay on it, you very well may need to discuss both. Is this a trespass? Is this a nuisance? Difference being with trespass, I mean, this is like kind of primitive, unscientific stuff. For a trespass, you need a thing with some substance invading. I throw my watch onto somebody's property, trespass. I shine bright lights on somebody else's property so that they can't sleep at night, nuisance. I make loud noises so they can't study for the bar exam, nuisance. I build a fire and smoke goes onto their land, nuisance. depends on sufficient particle size to turn into a trespass. Okay, trespass to land. Trespass to chattel and conversion. Chattel, that's what you go to law school for, so you can use words like chattel, right? Because real human beings do not use the word chattel, right? Only lawyers use the word chattel. This is a chattel. That's a chattel. That's a chattel. Things, personal property, chattel, as opposed to real property. Trespass to chattel and conversion are basically the same thing, except trespass to chattel involves a minor dispossession from your personal property or a minor injury. I ding somebody's car, a little bump, a little scratch. I move it a few feet, I dispossess them for a short period of time, trespass to chattel, for which they can collect damages to compensate them for the minor injury. Conversion. I have now done enough damage to somebody else's property or taken possession for a longer period of time. Result, if they want, they can require me to buy it. Not just to pay them to fix it. Okay, I take, without permission, Christina's car. I drive it to Dunkin' Donuts to get myself some tea. I'm intending to return it. But I don't just ding her car. I damage it so that it would cost several $1,000s to repair it. Substantial damage. Christina can either sue me in trespass to chattel and get the money to repair it, or she can sue me in conversion and require me to pay market price at the time of conversion, forced sale. That's all. Tested, yes, really tested. It appears, which amount of money can the plaintiff get? But interesting little cross-reference. I'm pretty sure they don't make this cross-reference in Barbary, so you'll just get it from me. Conversion as a tort. What are we doing with conversion? We're converting personal property, right? Chattel. What else in the world can we do with personal property other than convert them? We can buy and sell them, can't we? And where is the law about buying and selling personal property? Well, now known not as chattel but as goods. UCC Article 2, right? So here we have common law rules, conversion, but what if a person sells that same piece of chattel? Well, what would be the problem? Okay. Jones steals my very valuable watch. Jones sells my very valuable watch to Smith, who doesn't know it was stolen. I find out that Smith has my very valuable watch. Guess what? I sue in conversion. Smith says, wait a second, I'm a BFP. Remember them from property? I bought with no notice, so I should get to keep it. No. No. Common law of conversion says even if you paid for it and got it in good faith, you're still your good faith converter, and you have to return it if the person wants it back or pay for it to that person even if you paid somebody else. You don't get a good title from a thief, you get no title from a thief. The original owner can bring an action in conversion even against a good faith converter. This appears on the bar. In no place in the world does it appear on the bar more often than Connecticut. So anybody doing the Connecticut bar, this is a favorite Connecticut bar exam essay issue. Because Jones stole the watch from me, sold the watch to Smith. The sale is a sale of goods which would be covered by the UCC if there were any relevant provision of the UCC, which on that there is not. But the UCC says sometimes we're going to protect BFPs. I'm using that phrase BFP with the assumption that you remember the concept from property, a bona fide purchaser, a person who purchased property without notice, that somebody else had an earlier claim can defeat an earlier person. I'm assuming you remember that vaguely at least. Suppose I take my very valuable, by the way, this is a $12 watch from Walmart, so don't steal it. It's not worth it. But imagine it's a very valuable watch. I take it to Jones's repair shop. Jones is in the business, the jewelry business of repairing watches, and I give it to Jones and I say, please fix it for me. Jones says, sure, I'll come back in a week. In comes Smith to the store, sees the watch that has now been fixed, sitting there and says, hey, Jones, that's a wonderful watch. I really want that watch. How much? And he says, oh, $6,914. Wow, that's a steal for that great watch. I'll buy it right now. And he pays him. Conversion? UCC has a special narrow little rule that says if the owner entrusts his or her watch to a merchant, and the merchant is one who deals in goods of that kind, and that merchant, yeah, really, turns around and sells it to a person who is labeled by the UCC as a buyer in the ordinary course of trade who pays value without notice. It's like a BFP, right? Buyer in the ordinary course of trade who pays value without notice. We'll come to this when we get to contracts. Then that person gets to keep it. That person is protected, is not a converter. So be aware there's a relationship between the tort of conversion and potentially UCC sales. Most of the time it's still a conversion, but sometimes the UCC is going to protect it. That's it. Those are the intentional torts to the person and to the property. Now you read the outline and they'll give you examples in more detail, but it all's going to fit around torts to the person, 4 of them, torts to the property, 3 of them. And the final thing you need to be aware of with the intentional torts is defenses to intentional torts. A couple of basic, there's a list of about 12 or 13 in Barbari's outline, but I say basically what are they about and be aware of them. Assumption of the risk is not a defense to intentional torts. It's a wonderful wrong answer to an intentional tort multiple choice question. Assumption of the risk goes with negligence and strict liability. With intentional torts, same thing, but we call it consent, right? Instead of assumption of the risk, we say that's the kind of thing that the person either expressly consented to or impliedly consented to, because as a matter of living in this society, you impliedly consent to someone tapping you on the shoulder and saying, sir, what time is it? Something like that. Or, can you tell me where the train station is? Something like that. Implied consent. I assume the risk by being alive and going into a train station that someone might tap me on the shoulder. Okay, but we don't use the phrase assumption of risk. We call it consent. Read everything about consent. Consent is always going to be tested. Is this a valid consent? Has the defendant exceeded the scope of the consent? Cross-reference it eventually to crimes where consent also comes up. Second group of defenses to the intentional torts, a group where we're defending something. My defense is I was defending something. I was justified because I was defending myself, or I was defending a third person, or I was defending my property, or I was defending my chattel. One can use reasonable, whatever that is, force to protect oneself from a tort, from a battery, etc. Or to protect a third person, reasonable force from what reasonably appears to be an about to occur harm to a third person. I see someone about to hit somebody else, what can I do? Use reasonable force to protect that person. Same reasonable force I could use to protect myself. Much less force can be used to protect property because it's property, it's not a person. Read everything about those defenses. Fairly complex. If I went through all those rules, it'd be a half hour. I'm not going to do it. You'll read it. And necessity is the other big group. So we have consent, defense of various things, and necessity. Necessity comes in two flavors, private and public. Whenever you have two things like private and public necessity, you can figure you better know the difference between them because it's going to be important. Private necessity is one does something to protect oneself. Public necessity, you're doing it to protect the public. Private necessity, in order to protect myself from being stabbed by a wild bull, I jump over the fence onto Miss Sweet's land. I have a privilege to protect myself to jump over the fence. Private necessity. However, if I do any damage to her land, I'm still liable for the damage. I'm entitled to do it, but I'm entitled to damage. And she can't push me off. Public necessity, I go onto somebody's land to protect the public against some greater risk. I'm privileged to do it, and I don't have to pay. So there's a difference, right? What's public versus private, and what are the consequences? Intentional torts, we're done. That's it. Right? Torts the person, torts the property, defenses. And that's what you need to know, along with the prima facie case. Okay, moving forward to negligence. About half or almost half of the MBE questions, by the way, I meant to say this at the beginning, and the problem of talking extemporaneously without minimum notes is I didn't think to do it. I am attempting to cover in here the basics that are covered on the MBE portion of the bar, which is, bar in almost every state, but also to point to issues that are tested in essays in different states, so that I've actually been through the essays, all the essays for the last 10 or 20 years in at least 15 or 20 states. So California, Florida, Tennessee, New York, Massachusetts, New Jersey, Connecticut. We will refer to essays, refer to issues, particularly when they're ones that I've seen come up fairly often on essays in various states. Negligence is the far and away most common subject for essays in almost every state that gives torts essays. California, New Jersey, Massachusetts, Connecticut, Florida, and so forth. You have no business walking in to take the bar exam without feeling, I know my negligence law, I know when to apply it, and I know the basics, and I'm ready to organize it. Now, I'll talk at some later point about the grading system for the essays. Connecticut uses a 7-point scale, 1, 2, 3, 4, 5, 6, 7. 7 being best and best top 15%, 1 being bottom 15%, 4 being average. If you look through the released student answers, because Connecticut's the state that gives you samples of student answers at these various gradation levels, if you find a sentence in the essay somewhere that says in negligence, plaintiff must prove duty, breach, cause, in fact, practice, cause, damages, or basically says that, that essay almost certainly gets at least a 3, not a 1 or a 2. A 3 is not quite passing, but it's close. It's not, if you just wrote an essay and you said in negligence, this is what the plaintiff must prove. Now, that wouldn't do it, right? But anybody who actually does say that almost certainly is going to be writing at least a 3. That much structure is almost certainly going to lead you to get at least a 3. So I guess I've kind of given away what are the elements or what's the prima facie case in negligence. And that's the one that people often remember from first year. In negligence, now I've got it, okay. There are 50 different ways, 100 different ways in which you could state a prima facie case. Some people want to say negligence is these things, battery is these things. I think you want to put it in the legally assertive, appropriate context. The prima facie case are things plaintiff must prove. So just say, in negligence, plaintiff must prove. Now you're telling the reader, and the readers, after all, are lawyers, practicing lawyers, right? I'm a lawyer, you're a lawyer. This is what the plaintiff must prove. You sound like you know what you're talking about. You probably do. In negligence, plaintiff must prove, and don't add excess words, we're just putting down a definition. Duty, breach, actual cause, proximate cause, damage is done. Because now we can take each of those so-called elements and prove them, right? The most important element in negligence is duty. Most important because, observe, Barbary gives about 15 pages to one element of one tort. No other element of any other tort gets 10 or 15 pages. So we got to see why. Let's start with the general rule of duty. If I told you my opening sentence, after saying in negligence this is what plaintiff must prove, my opening sentence would be, there's a duty of reasonable care to foreseeable people. I hope that wouldn't surprise you. That's the general rule. And throughout the law that we're going to be studying, we have general rules with exceptions, and you want to generally start, my general rule is start with the general rule. Don't go to a hearsay exception before you discuss whether something is hearsay. Don't go to, well, character evidence is admissible for this purpose without first saying, in general, character evidence is inadmissible, and then go to the exception, right? So the general rule of duty is when one is engaging in any kind of activity, one owes a duty to people who are foreseeably injured. Remember Mrs. Paulsgraf and her case, maybe from first year? People, as Justice Cardozo put it, who are in the zone of danger. But to put it in more modern terms, people who are foreseeable. I'm engaged in a certain kind of activity. Who is foreseeably injured? Not Mrs. Paulsgraf. Given the nature of the activity of helping somebody get on the train, it's not foreseeable that I'm going to injure somebody way down at the other end of the platform. They're outside the zone of danger. They're not foreseeable, so says Cardozo. So, people within the zone of danger, and what do I owe them in general for every activity that I engage in? Driving a car, throwing a ball, whatever, shooting a gun. I owe generally a duty of reasonable care to people foreseeably injured by my activity. That's such a, at least just to state it, such an easy thing to state. You can't give a lot of questions on it. But it can turn out that the duty rules are very heavily tested. Why? Because there are tons of exceptions. It's kind of like the rule against hearsay, tons of exceptions. Well, with that general duty rule come all the following alternative standards of care. Standards of care. What? If someone, the defendant's a crazy person, reasonable person standard, even if they can't do it. Someone's an old, doddering person, just barely, but no special standard. But if the defendant is a young child, special standard of care. Instead of the standard of care of an ordinary reasonable person, objective, ordinary reasonable person, with a young child, we say the standard of care will be the standard of a child of like age, experience, and intelligence. If he's young, inexperienced, and stupid, then we can't expect much of him, and we don't expect much of him. But if that young child is engaged in an adult activity, whatever that is, driving a car, shooting a gun, question, then all of a sudden we're back up to the adult standard. That's tested a lot. Professionals, doctors, lawyers, architects, people who have some specialized knowledge, hold themselves out to the world as having that specialized knowledge. I came to you because you're a doctor, a lawyer, or whatever. Then we expect more than just ordinary reasonable care. We expect the person to conform to the professional standard, whatever that is. And since the jury is not made up of professionals, we actually need testimony as to what that standard of care is. We need to put people on the stand to testify. This is the standard of care of the relevant professionals. Standard of professionals in the same or similar localities sometimes. Standard of care on a national basis for more specialized behavior. Tested all the time, particularly essays. Connecticut loves it in essays, other states love it in essays. So do we have a professional standard of care? How do we prove it? Have we proved it? But that's just the beginning. We have to deal with what's the standard of care if someone is a bailor or bailee? Again, people who didn't go to law school don't use those words, do they? I don't think so. We just formed a bailment. Yes, okay. And was it a bailment for hire or a gratuitous bailment? If you don't know what those mean, you at least have the tools from law school to figure out. Bailment for hire, I'm paying for it. Gratuitous, I'm not paying for it. Bailment, I'm entrusting personal property to someone. One person is the bailor. I'm the bailor. I take my watch to Jones and entrust it to him. He's the bailee. What are the duties of the bailor to the bailee, the duties of the bailee to the bailor? And they're going to vary depending on a number of things, including whether it's for hire or gratuitous. Read the outline. Emergencies. I'm in an emergency situation. Should the jury take that into account in deciding whether what I did was reasonable? Yeah. So there are all sorts of specialized rules, many, many. But there are two big areas that are particularly heavily tested that I want to point out to you today. So when you're reading the outline, say, oh, those are those rules. Number one of these really heavily tested areas of duty, owner or possessor of land duties. If the defendant, not the plaintiff, if the defendant is an owner or possessor of real property, the duty that person has to others is quite variable depending on what state you are in. So now let me make a caveat. There are two very minor jurisdictions, New York and California, that don't follow these rules at all, that just say we use reasonable person. But it's still majority rule in the United States that we have special standards of care when the defendant is an owner or a possessor of land. Not just someone who's on land visiting me, but the owner of the land or the possessor of the land has different duties. Now, this could be less complicated, but it's not. If we're talking about the duties of the owner or possessor to people not on the premises, people off the premises, we have one set of standards. If the person is on the premises, we have different standards. Oh my God. And if the person comes onto the land, that person might be a trespasser. Either an unknown trespasser or a known trespasser. Or might be a licensee. Or might be an invitee. Which are all technical words that you as lawyers need to understand. And depending on which category the person falls in, the standards are different. But it also depends, oh my God, actually I discussed this in a package I'm going to hand you later, either today or next time. Depends on whether the injury is caused by an activity of the defendant on his land, or whether it's caused by a natural condition on the land, or whether it's caused by an artificial condition on the land. Oh boy, can you see how many multiple choice questions you can make with all this complexity? So it's always going to be a couple of questions. If the owner, and this is really true, if the owner or possessor is engaged in an activity on the land, he's riding his motorcycle on his own land. No special rules. That's an activity on your land. You have a duty of reasonable care to foreseeable people. If there's an unknown trespasser, you have no reason to foresee him, whatever. But if it's somebody you can foresee, whatever, you have a duty of reasonable care for activities that you're engaged in on the land. If it's a natural condition on the land, I have trees on my land. Generally no particular duty, those are natural conditions. Somebody walking in my forest, it's forest, no particular duty. Where we get the special rules is with artificial conditions. Things that are made by man or woman. Human-made things. Houses, bridges, anything made by a person. If we have an artificial condition on the land, the duty to a trespasser is no duty at all if he's unknown. You'll see this in the Barbary outline. I'm just pointing out this is important stuff to you. If the trespasser is known or anticipated, the owner has reason to know people are trespassing. If that's true, then the duty is one, to warn or take reasonable steps to make it safe if the artificial condition creates a risk of serious harm to person, serious harm or death, and if the owner knows about it and the trespasser is not likely to discover it. Oh, that's complicated. All sorts of multiple choice questions built in there, right? It's got to be highly dangerous. Owner has to know about it, so you don't have a duty to inspect, but if you know about it, and it has to be the kind of thing trespasser is not likely to recognize or see. My highly dangerous condition, artificial condition on my land is in order to keep trespassers off the land, I put very, 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 very sharp barbed wire atop a big wall to keep people off my land. That's an artificial condition. I put it there specifically because people have been trespassing. I know they're trespassers. But damn it, it's visible. It's obvious. So I'm not breaching if I don't warn or make safe. Right? It's got to be something trespassers not likely to discover. Okay. Licensees, a little bit more of a duty. Invitees, much more of a duty. If somebody's classified as an invitee, now the owner has to go inspect the land looking for such things. So see, how we categorize these things tells us what the duty level is. All those complex rules about owner-possessor duties and when those rules apply and when they don't apply is something you are certain to see for a couple of questions on the exam. The other big area of duty you are absolutely certain to see is this: statutes. When there is a statute that would apply to what occurred in the particular case, criminal statute, don't cross the solid yellow line, don't park next to the fire hydrant, punishable by some fine or maybe even imprisonment. The statute doesn't say anything about tort liability, then courts will use the statute instead of the reasonable person standard sometimes. Instead of instructing the jury, ladies and gentlemen of the jury, reasonable person, you decide. Instead, the court will sometimes say, ladies and gentlemen of the jury, the legislature set the standard of care here and it's don't cross the solid yellow line, so if you find the defendant crossed it, that's a breach of the duty. Just get to causation damages if you find he breached the statute. But we don't use every statute to set the standard of care. This is the doctrine called negligence per se, widely referred to as negligence per se. We use statutes to set the standard of care if and only if the plaintiff is in the class of people the statute's designed to protect. And if and only if the injury that occurred is of a kind that the statute was designed to protect against. Class of plaintiff and class of risk. So this requires that you actually think, well, why did they adopt such a statute? And they're never going to tell you on the bar what class of people it was designed to protect or whatever. You have to figure that out. So they're going to give you really obvious ones like don't park next to a fire hydrant. They're going to assume that you can figure out don't park next to a fire hydrant is there to protect buildings and people from fires, to provide access to a fire hydrant in case a fire truck needs access. It's not there for any other, it's not a crime for any other reason, right? You're going to have to figure out what's the purpose and class of plaintiff, class of risk. We don't apply the statute as a replacement for reasonable person unless we can show class of plaintiff, class of risk. And finally, we still don't use the statute to set the standard of care if the defendant offers an excuse or a justification. Like, it was an emergency. There was no other way to do it. Whatever. Some kind of emergency justification. If the defendant offers evidence of an excuse, even though the statute was designed to protect class of plaintiff, class of risk, it turns it back into a jury issue because the defendant says, yeah, but I did it for a good reason. Now the jury gets to decide, was taking into account the statute and the defendant's excuse, was the defendant's behavior reasonable in light of all of this? very heavily tested. Always a couple of questions on the multi-state, always, just on that. An extremely regular issue on essays. I'm not taking questions till the end. Okay? So we have landowner occupier rules, we have statute rules, and there are only a couple other things I'm going to talk about with duty in negligence. Number one, something that you may remember in the back of your minds from first year. In general, in our law, there is no affirmative duty to help anyone. You can watch somebody drown, and you don't have to go to the rescue. Oh, look at that young girl drowning. You can be a callous, nasty, heartless person and still not be liable in negligence. No affirmative duty to act. With, as with many general rules like that, lots of exceptions. There is a duty to act if you put the person in the situation of peril. I own the swimming pool. I opened it up. I put her in there. Or if the person, there's your daughter, you have a family relationship with a person. Employer-employee sometimes. So the number of exceptions when we do say there is a duty to act. Or you began a rescue and then you said, I started to rescue the person and then I saw, oh my God, the person I'm trying to rescue is Newt Gingrich, he doesn't deserve it. And you push him under the water, right? No, you can't do that. Once you undertake to actually give assistance, you can't make the situation worse and stop. Okay, so affirmative duties, generally no, but with lots of exceptions. And the one other thing in terms of prima facie case for negligence is NIED. Remember I referred to that earlier? Negligent infliction of emotional distress as opposed to intentional infliction of emotional distress. I wouldn't conceptualize this as a separate tort. It's just negligence where the injury is emotional distress. We still have to prove duty breach, etc. But the question is, if the only injury is emotional distress, then traditionally courts said, no, that's not enough. You need, the damages we need for negligence are generally injury to the body or injury to chattel. Emotions are not enough. But modern trend, widespread, if the negligent behavior of the defendant doesn't quite cause bodily injury, but the plaintiff was in the zone of danger. Car screeched to a halt 3 steps away from him, and then he suffered emotional distress. You can get negligent infliction of emotional distress even though there was no contact. Generally requires emotional distress plus some physical consequence thereof, vomited for 3 days or whatever. But emotional distress is the essence of it if you're in the zone of danger. Number 2, there are some areas of human life where the courts have determined emotional distress is believable in these areas, so we're going to allow it even if the person was not in the zone of danger. Like, believe it or not, cases happen all the time. Negligent infliction of emotional distress for mishandling of somebody's corpse. Right? I am upset because the hospital mishandled my father's or mother's corpse. Yes, negligent infliction of emotional distress. Third, negligent infliction of emotional distress if I see a close relative being negligently injured. I'm not in the zone of danger, but I'm nearby and I see a close family member being injured, and as a result, I suffer emotional distress. Most states recognize that as a basis for negligent infliction of emotional distress. Other than that, no. And that's the duty rules. Now, I'm going to give you a break, 10 minutes. Go. And anybody has any questions, they can come up now. Okay. Christine, let's turn.